Welcome, everyone. As people are filing in, I will get started by introducing, and I would like to thank you for joining us. My name is Becca Franks. I'm an assistant professor of environmental studies here at NYU, and I'm joined by my colleague and co-host, Professor Jeff Sebo, who, among his many, many hats that he wears, is the director of our Animal Studies graduate program and is the director of the Mind, Ethics, and Policy program, which is a co-sponsor of this event. We are also joined by the wonderful Sophia Fogel-Davis, the program coordinator of Mind, Ethics, and Policy, and Phoebe Miller, our departmental administrative aide. They're both going to be helping us run the show today. We're coming to you from the Department of Environmental Studies, which houses NYU Animal Studies as a BA minor and an MA graduate degree, and is further supported by the Center for Environmental and Animal Protection, also known as CEAP. Together, we aim to contribute collaborative, interdisciplinary, and groundbreaking research to understanding who animals are, how humans relate to the more than human world, and the moral, social, political, legal, and ecological significance of those interactions. We also recently launched the Wild Animal Welfare Program, which Jeff and I co-direct, and supports foundational research on what wild animals are like, how humans and wild animals interact, and how humans can improve our interactions with wild animals at scale. We're very excited that the Wild Animal Welfare Program is now accepting submissions for an early career award and workshop. We invite graduate students and early career faculty or researchers in any field to submit current or recent work on the topic of wild animal welfare. Winners will receive an award and an all expenses paid trip to the 2023 NYU Wild Animal Welfare Workshop this fall, where they'll be invited to present their work. If you'd like to learn more about this opportunity and other departmental programs, please check out our website and sign up for our events list. So moving on to today's event, this is a part of an ongoing series of public talks made possible by generous support from the Brooks Institute for Animal Rights, Law, and Policy. And this panel is a discussion for the book launch of the new book, Animal Rights Law by Raffael, Fasel, and Sean Butler. In addition to the authors, we are also joined by two discussants, John Adenatire and Joyce Tischler. After I introduce the panelists, we'll hear directly from the authors, followed by reflections from the two commentators and brief replies from the authors. We will then open the floor up to Q&A from the audience. To participate in that Q&A, you're able to enter questions directly into the Q&A tab throughout the webinar. You should be able to see that tab right now at the bottom of your Zoom screen. And so if you like, you can enter your questions and comments into that interface. And you can also upvote other questions or comments that people have asked as the talk progresses to indicate your interest in hearing responses. We look forward to a lively Q&A session, so please do add your questions and comments as they occur to you during the lecture. And so with that, it's my great pleasure to introduce our panelists. We'll first be hearing from Sean Butler, who has been a fellow at the St. Edmund's College since 2002. Previously, he worked at Shell and Nokia. He studied law at Oxford at St. Edmund's Hall and the London School of Economics, as well as genetics at Cambridge, before taking his PhD in social sciences at Imperial College London. He specializes in intellectual property strategy and life sciences and technology-based startups. He is also CEO of Cambridge Agritech, a syndicate of investors on agritech startups. He is the director of studies in law at St. Edmund's and teaches Roman law and animal rights law. Raffael Fasel is an affiliated lecturer at Cambridge Law Faculty, a visiting fellow at the Shell Center for International Human Rights at Yale Law School, and is an affiliate with the University of Zurich. Raffael was previously teaching by fellow and director of studies in law at Jesus College, Cambridge, and fellow in law at LSE Law School. He obtained his PhD in law from the University of Cambridge, Sydney Sussex College, with a thesis in the legal theory and intellectual history of human and animal rights, for which he was awarded the university's York Prize. Our discussants, first we will hear from John Adenatire, who is a senior lecturer in the School of Law and a fellow of the Institutes of Humanities and Social Sciences. Prior to joining Queen Mary, he was a lecturer in law at the University of Binghamton. He completed his PhD at University of Cambridge, Faculty of Law, and Fitzwilliam College. He is currently writing a book on animal and constitutional theory for Oxford University Press. And finally, we have Joyce Tischler, who is professor of practice, animal law at the Center for Animal Law Studies at Lewis and Clark Law School. In 1979, Professor Tischler founded the Animal Legal Defense Fund and served as the ALDF's executive director for 25 years and as its general counsel until the spring of 2019. Professor Tischler's early experience in the field of animal law is detailed in her two-part article, A Brief History of Animal Law, Part 1 from 1972 to 1987, and Part 2, 1985 to 2011, published in Stanford Journal of Animal Law and Policy. Professor Tischler is also co-authoring a case book on industrialized animal agricultural law. And so with that, without further ado, thank you all for being here, and please join me in welcoming our first panelists.
Shall I start? Becca, Jeff, thank you very much for inviting us. So Raffael and I are going to take a few minutes separately to talk about the book and the background to it. We've been teaching animal rights law at Cambridge now for about 6 years. We started in October 2017. We put together a program, 16 one-hour lectures. We thought it would work together as an interesting subject, primarily for law students at Cambridge. In actual fact, in our first year, we got students from the law faculty, but also from environmental studies, from the veterinary school, so a wide range of students, and that was very pleasing. We refined the course since then. It was initially an informal course, so we didn't seek or get approval. The law faculty in Cambridge was very good to us. It gave us a room, gave us a lecture room, and put us on the timetable, but warned the students that it was a non-examinable subject. Fast forwarding, 2 years ago, the law faculty at Cambridge approved animal rights law as a degree subject. So now it's an optional course for third-year law students who are interested. They can take the course and will be examined on it at the end of the year. Examinations are coming up in a few weeks' time, so they'll sit a written exam on animal rights law, and the results will be part of their university degree. So Raffael and I obviously absolutely delighted about that, because in terms of validation as a subject, we think it's a great outcome that the university's chosen to approve us. Hopefully it's a sort of something which will be an encouragement to other universities around the world teaching law to add it to their law degrees. Obviously there's animal law and animal welfare being taught. Hopefully they'll add animal rights as well. The book emerged from the lectures, so there's hopefully a nice fit between the sort of ideas we talk about in our classes and the ideas in the book, both in terms of the subjects themselves, but also the sort of sequence in which we introduce them to our students. So hopefully there'll be a certain logic if you read the book, to following through, seeing where animal rights, starting with the ideas of welfare and moving through to the idea of what actual animal rights might look like in a legal system. So we're hopeful also that the book will be useful for law lecturers who are interested in teaching it, something they can set for the students. About 2 years ago, Raffael and I started a UK educational charity, the Cambridge Centre for Animal Rights Law, and we started that because there was a lot to be done, more to be done, we felt. People wanted to come and work with us, and we wanted to engage more with more ideas and more research and teaching. So we set it up as a charity, and in fact, our first donation to get us going was given to us by the Brooks Institute. So that was again a great support. The center does all sorts of things you can imagine, like any other center, conferences and workshops and academic visitors and so on. But one of the most recent things we decided last year was that we wanted animal rights law taught widely. So we now set up a program, Law Lecturers Workshops, and we're doing 2 a year, and they're designed to support law lecturers who'd like to teach animal rights law. So we have, as I say, 2 workshops a year, 10, 12 people come to each. The next one's in a few weeks' time in Vermont, because we have an objective of 100 animal rights law courses being taught around the world in the next 5 years, and hopefully with growing interest in the subject and perhaps some help from our workshops, we'll see that sort of outcome. And I think before I hand over to Raffael, what we were trying to do, obviously this animal rights law has a long history, obviously not as long as animal welfare laws. It's got a long history, and what we wanted to do was perhaps help bring it together to develop it as an emerging discipline, and to give it a roundedness that would make it easier both to study and see where the component parts in, and to research in it, so that people who want to study animal rights law can see it in the round and decide what sort of aspect they want to study. Hopefully an increase in the number of courses and encourage a wider interest, more people doing research degrees, PhDs and so on, and just more students taking the courses generally. And so hopefully the textbook will be part of all that. Raffael.
Thanks, Sean. And I'm just going to share a slide with you now, just to show everyone what the textbook looks like. I'm going to speak a bit more about the content of the book, and I'd also like to reiterate my thanks to Jeff and Becca for hosting this book launch. We're delighted to be able to be here. So I've personally been to a few book launches where I never quite found out what the content of the book was. So I want you to go away with at least a basic understanding of what the book does, and perhaps you're going to be tempted to get a copy. You'll find discount codes on this slide here. If you want to purchase a copy from the US or Canada, you can find the code here and just type it into bloomsbury.com. So first I'd like to say a few words about more the formal content of the book before discussing the substance, the chapters that it contains. As far as the formal content is concerned, I'd like to just flag 3 points. The book was written with a view to making it accessible. So if you don't have a law background, that doesn't mean that you can't read the book. We have a glossary at the end of the book that explains the most important terms. We try to avoid sort of legalese where we could throughout the book. So it should be really quite accessible, easy to understand. It's also got some exercises in it. So if you're thinking of maybe using this to, teach a class, or just to help, you yourself, work through the materials, you'll find some helpful sort of questions and more creative exercises that you can use for that. So we've got the point of accessibility. The second one is it's a global textbook. So we didn't write a UK textbook or, German textbook, US textbook. The focus is global, meaning that we've got over, I think, 30 jurisdictions that we're using, sort of examples from, both common law, civil law countries. And if you're interested in a jurisdiction we don't cover, we've got an extra website, a sort of companion website that comes with the book that covers even more jurisdictions. So there's really something for everyone in this book. It's not just for people from one jurisdiction. And so lastly, there's the element of it being a balanced book, or at least we try to write it in a balanced way. Maybe Joyce and John are going to have their own views on that. Maybe we didn't succeed, but we certainly didn't want to just present one argument or one view. We wanted to present the debates and then let the readers decide for themselves which view they agree with, which view they disagree with. So we've got this accessibility, the global focus on, and the balanced nature that sort of characterizes the book from a formal point of view. Turning now to the substance of the book, which chapters does it actually contain? What sort of ground does it cover? It's got 8 chapters. The first chapter is on the current legal status of animals. Here we basically just present a map of where we are right now as far as the property status of animals is concerned, welfare laws, anti-cruelty laws, and what some constitutional and international laws look like. We then turn in the second chapter to the question where we should be going by looking into the welfarism and abolitionism debate. And indeed, we discuss whether, this welfare abolition dichotomy is in fact problematic and that we should be going potentially beyond that dichotomy. In the third chapter, we turn to the philosophical foundations of animal rights. So here we discuss the most important philosophical theories, from Singer to Nussbaum to others, and also some critiques of animal rights, including contractualist critiques, conservationist critiques, which may be of particular interest to some people in the audience here. Having discussed the philosophy of animal rights, we then turn to the legal theory and we ask whether animals in fact already have rights in the law, whether they would need to be legal persons to be rights holders. There's some knotty jurisprudential questions that we discuss in that chapter. In the fifth chapter, then, we discuss the relationship between human rights and animal rights. And we ask, well, if animals have human rights, if they have animal rights, what does that do to human rights? What if there's conflicts between human rights and animal rights? Can they be resolved? Are these rights cut from the same cloth, or are they in tension with each other? That's what we discuss in that chapter. And then the last 3 chapters look at more sort of animal rights on the ground. We look at litigation efforts, sort of standing cases, habeas corpus cases, cases that go beyond habeas corpus. We look at animal rights in legislation, what kinds of legislative proposals have been brought on a domestic level, international level, and we even look into sort of how they could be drafted. And then the very last chapter of the book is on animal rights as a social justice movement. So here we ask what animal rights advocates can potentially learn from other movements, whether there's connections to other movements and what that might entail. So that's broadly an overview of the 8 chapters of the book. I'd be happy to go into more detail in the Q&A if there's specific questions on one of these chapters. But I'll leave it there and I look forward to hearing from the discussants now.
Perfect. I think that means it's my turn. Okay, so first of all, I want to thank the organizers of this event, but of course this event wouldn't happen without Raffael and Sean having written this wonderful book. I've had the privilege to be one of the first students to the course at Cambridge when this book was being prepared. And when the course that was on which this book is based was being offered at Cambridge. And then I was a second beneficiary again by Sean's and Raffael's work when they organize a animal rights law teachers workshop. And then now I'm third time lucky because I not only have this wonderful book, I can also refer it to my students, and I'll make sure that the students buy it in droves. And jokes apart, this is a really wonderful book. The authors do succeed in making the readability of the book highly accessible to everyone, and the structure is really wonderful, and the book covers all sorts of things. So I don't think it's possible to give any higher praise to this book. It is, yes, a textbook, so it introduces readers to many of the issues in animal rights law, animal welfare law, etc. But it does more than that. It really does map many of the crucial themes that advanced researchers are working on And so even though I've been teaching animal rights now for 4 or 5 years, I learned quite a great deal in this book by rereading it. So I want to really compliment Raffael and Sean in this wonderful achievement. So in the few minutes that are left to me, I'm supposed to say something bad about the book. Yes, because that's what apparently academics are supposed to do, critique work. That's the highest form of praise. So it is really hard to find an angle to critique this really wonderful book. So the only thing I will say to critique the book is perhaps the book is looking too far into the future. It's being a little prophetic, right? Because perhaps the expectation of students when they learn that there is an animal rights law book is to say, well, animal rights must be a booming field in the law, right? So we need a textbook to be able to really get to grips with this with this really complicated area of law. But as it so stands, and the authors acknowledge this in their very introduction, there are very few animal rights laws, if at all. And this is part of my critique, but of course it will become also part of my praise for the book. So what does it mean that there are no animal rights in law? It means, first of all, this entails really understanding what animal rights is in the first instance, and then actually investigating whether there are any such animal rights in the law. So the authors very adaptly give us an overview of welfare provisions, especially I think in the first few chapters of the book. So-called animal welfare laws that we are familiar with, that protect certain interests of animals in not suffering unnecessarily. And they say in the book that these are sometimes called by legal theorists as thin rights. Okay, but that there are other kind of thin animal rights. But there's another category with which the book is centrally concerned, which are thick rights, thick animal rights. And they say that thick animal rights should be distinguished from thin animal rights, among other things because thick rights protect the fundamental interests of animals. I think this is, of course, only one of the distinguishing feature they say distinguishes thick from thin rights. There are other features that they say distinguish thick rights from thin rights. One being that, another one being that thick rights cannot be easily balanced away against other considerations. There are others. They point out to 6, in fact, in the book, but I'll leave that to the readers. But I want to suggest that this differentiation between thick and thin rights actually doesn't get to the heart of the matter, because there are many thin rights that protect many fundamental interests, including the rights to life. So there may be some conservationist or pieces of legislation or legislation that protect endangered species, that actually protect the life of certain animals. Even welfare laws that apply, say, in the US or Europe, etc., sometimes do protect very important interests of animals, such as not suffering. The interest in not suffering, which we could say is actually a really fundamental interest. Yes, it is true that the right to life of many of the animals is not protected, but just saying that the one of the distinguishing features of thin and thick rights is that certain fundamental interests are not protected, I think doesn't go to the heart of the matter. of the distinction. So what I want to suggest is that what really distinguishes real animal rights, so thick rights from thin rights, is a particular ethic, is an ethic of non-instrumentalization or non-exploitation of animals. That animals are not things or beings that to be used merely for human purposes. And we can see that if you accept that this is the ethic of strong animal rights, of actual animal rights, however we want to call them, thick animal rights, then welfare laws cannot be characterized as animal rights at all. Because as Will Kimlichler says, actually welfare laws, what they do is justify the exploitation of animals, right? One way then, the subsequent question then is to say, yes, perhaps we can distinguish thin and thick right from this ethic of non-instrumentalization. Thick rights or genuine animal rights are distinguished by this idea that animals are not instruments, they are not to be exploited. So are there any animal rights in the law? So clearly the many and abundant animal welfare laws cannot be characterized as animal rights. There are certain legislative proposals that the authors look at towards the end of the book that may be characterized by this ethic of animals as no exploitation, but as they readily admit, these legislative proposals are just that, they are proposals. So then if we look at the law, the legal recognition in some courts, including some of the habeas corpus cases, it seems that maybe we'll be better off, maybe that we can find some animal rights in those cases. But even then, look at the most recent case, one of the most recent cases. I think I was lost there for a second. One of the most recent cases is the Estrelita case. But again, the Estrelita case, if I remember correctly, decided in Ecuador. While recognizing certain fundamental rights of animals through the recognition of protection of nature, still allowed these animals that are protected by this right and all other animals, wild and domestic animals, to be exploited, to be instrumentalized. And the same goes for certain cases in India, where these rights are recognized. Animal rights at the constitutional level are recognized, but yet the Indian Supreme Court, Constitutional Court, allows the instrumentalization of animals for mere, for not very compelling human uses, such as food, experimentation, etc., etc. So then my account is a little bit perhaps more pessimistic than Raffael and Sean's. I think there are maybe no animal rights in law yet. So what should we make of the book? Is it too early? Well, I don't want to end on this negative note. Actually, we know that there are pioneers in the world, people that set the path that others should explore. And I think this is the role of this book. Raffael and Sean are pioneers. They set the stage for what could be and what should be in the law. So I think what was supposed to be a big critique actually turns out to be perhaps the greatest praise for this book. It really sets the path for what will be or may be in the future. So thank you again, Raffael and Sean, for writing this wonderful book. Thank you.
I'll take it from there. Thank you, John. The development of animal rights as a philosophical concept has been and continues to be quite exciting. But one should not underestimate the task of moving from the philosophical analysis to the creation of legal rights for animals. That's more of a moonshot. No matter what country you live in, the legal system is structured in a way that maintains the status quo. And trying to change that legal system in any way is a massive task. And that needs to be understood in reading this book. Creating legal rights for animals is not at all like opening a packet of oatmeal, pouring in the boiling water, and voila, it happens. And that's painful for each of us, because we realize that most animals are suffering terribly, and each of us wants to free them from their abuse yesterday. But it's naive to think that one can create rights out of whole cloth or easily. I feel very lucky to have witnessed some of the legal efforts to create rights for animals from the earliest days, and I doubt that I will be alive to witness more than preliminarily modest gains. But I am quite encouraged by the scholarship that is in animal rights law. What Raffael and Sean have written enables the reader to understand the complexities of animal rights theory, how to date that has been translated into legal language in several countries, as well as what's needed for the future. And changing how the legal system views and treats animals is literally a matter of trial and error. Creative attorneys have come up with legal theories, taken them to the courts, and suffered the slings and arrows of judges who, in most cases, really can't imagine a legal scenario in which animals other than human beings should or could be acknowledged as holders of rights. And that shouldn't be surprising. New ideas are almost always met with derision and laughter and astonishment. That's part of the process. And I think that Sean and Raphael have captured that well in this book. I was especially pleased to read the chapters that describe the litigation and the legislative strategies that have been tried, some of which have been successful to some extent. The authors walk the reader through the major lawsuits that have been filed, the extraordinary 2016 case of Cecilia the chimpanzee, who was declared to be a non-human legal person in Argentina, and a writ of habeas corpus was granted, which enabled her to be moved from the solitude that she was kept in at a zoo to a sanctuary where her needs could be better met. And the authors also review the cases brought by the Non-Human Rights Project on behalf of chimpanzees and elephants and soon dolphins. And I'm quite familiar with those cases. In reviewing the summaries of the cases, it occurred to me that the reader can really get a sense of a legal system that is highly resistant to granting legal rights to animals. The authors reference Stephen Wise, who is the creative force behind those NHRP lawsuits. He's a dear friend and colleague of mine for over 40 years. I have a copy of the very first law review article on granting legal rights to animals. Steve Wise wrote that with David Faber, who's also mentioned in the book, in the early 1990s. And you know, that article was never published because they couldn't find a law review that would publish it. So far, none of the habeas corpus lawsuits brought by the NHRP have been successful, if you measure success as getting the animals away from their exploiters. But success is often measured by the spoonful, and reading those decisions is eye-opening. The opinions of those judges show us a legal system grappling with new concepts, judges who are just beginning to understand why other animals might be holders of legal rights. And that becomes quite apparent in the Happy the Elephant lawsuit, which is described in the textbook. That's a case in which NHRP sought a writ of habeas corpus on behalf of an elephant who is imprisoned in isolation without the company of another elephant, and she's at the Bronx Zoo. And as we all know, elephants are highly social, emotionally complex individuals in their natural habitat. They live in matriarchal societies. They raise their young for an extended period of time. They walk many miles per day in search of food and water. They grieve the death of family and herd members. They do not live well or belong in captivity. They do not prosper in captivity, where they can't walk enough. An elephant like Happy, who is kept in isolation, is anything but happy. And they really don't belong in the confinement associated with zoos or circuses. And as the authors told us, the majority opinion, which denied the writ, was fairly mundane, although the judge who drafted the opinion gave us some quite lovely language, which the authors quoted. She said, she described Happy as an extraordinary animal with complex cognitive abilities akin to human beings. Went on to say that she is an intelligent, autonomous being who should be treated with respect and dignity, and who may be entitled to liberty. That's lovely language. That's in and of itself, it doesn't seem like much of an achievement, but the fact that judges who in their day-to-day lives are not looking at this sort of material are thinking about it. That's part of the process. We have to accept that as part of the process. They need to become familiar with the language that animal rights attorneys are feeding them. The majority of the court understands what it's being asked to do. It's simply willing at this point in time to do that. But what's absolutely remarkable at that case, and the authors really caught this, is the 70-page dissent written by Judge Rowan Wilson. And I do recommend reading that dissent in its full form. When I read it, I thought it could have been offered by Steve Wise himself. Judge Wilson fully comprehended why Happy should have legal rights, and he argued on her behalf quite eloquently. One of the techniques that the authors used in this casebook is to provide the reader with a link to their companion website. There's a little icon that I can't figure out what it is, but I saw it in several places in the book, and the reader's being told you can do a deeper dive into the subject matter if you go to the website. And I hadn't seen that approach before, and I think it's innovative. And I thought it was a great idea to add those little icons in for people who want to get additional information. The Happy case differs greatly from most of the other opinions described in the text. And as Sean and Raffael have noted, the judges often speak in very flowery language. And you're left scratching your head, because then the decisions are either relying on welfare law or they're really quite mundane. And the authors, I think, give you a very clear sense that the judges are confused. They are unsure of what animal rights is, what the terminology is. Their holdings are what the authors refer to, and John mentioned thin, T-H-I-N, thin rights. I'm of the school, I would characterize those as embellished welfare. To my mind, true or thick rights have to be enforceable by the rights holders themselves. Too often, the judge is faced with deciding the question of whether a non-human animal can be declared a holder of legal rights. They offer a vaguely worded right that is too limited or too easily balanced away by a conflicting human right. And that just is what is at this point in time. The legislative efforts covered in the text offer impressive examples of what efforts have been made to date to grant legal rights to animals. The Swiss initiative described by the authors would have offered a constitutional right to life, bodily and mental integrity to all human primates, non-human primates. The human primates have that right. The validity of the initiative was challenged in court, and the court allowed the initiative to be brought to the voters, and the voters rejected it by a very wide margin. As ever, trying to get society to change, And that's exactly what animal rights law is trying to do. It's a heavy lift, but it's also a dance between those who would advocate for the change and those who seek to maintain the status quo. Granting legal rights to animals in a world in which they are used and abused most of the time because they are deemed essential to human existence, that's not going to come easily or quickly. And that brings me to my final point. Animal rights law is in its infancy. If I can stand back dispassionately and observe the process, it is quite thrilling. It reminds me of when I visited the big island of Hawaii, which is still forming. The volcano erupts, the lava comes down the hill, and new land is formed. And you can walk on land that wasn't there a few months earlier. To me, that is what animal rights law is right now. It's forming. John asked the question, was it too soon to write this book? I think it was not too soon. I think it could. I'm thrilled to see it. It couldn't have come too soon for me. As an animal advocate, the development of animal rights in law is frustratingly slow and confusing. And the authors have captured this process at this point in time, and they offer us a clear and concise perspective on what animal rights law is right now, and maybe what it could be in the future. And with that, I will hand it back to you.
Great. Thank you so much, Joyce, and to all of the speakers, the authors, as well as the commenters. I would like to invite the authors to offer any brief replies that they might have to some of the main points raised in the commentaries. And then we will have plenty of time for discussion. And there are already some questions and comments coming in from the audience. I would encourage others from the audience to please feel free to enter any questions or comments. Unlike most of our talks, which are about specific aspects of animal law, this is the rare talk that is literally about all of animal law and animal rights law. So now is your time to ask any question about any arcane topic within animal law or animal rights law that might not otherwise be featured in one of the talks in this series. So please do feel free to enter questions and comments in the chat and to upvote other ones. And as you do that, I will pass it back to Raffael and Sean in case they have any responses to the commentaries.
Thanks, Jeff. Sean, are you happy for me to go first? Okay. Thanks so much, Joyce and John. These are really thought-provoking responses and sort of observations. I think you're both spot on, and I don't really have much to add, but I think I'm going to just say a few things about what John was saying. And we hope that there will be a second edition of the textbook. So, this all critique and, all kinds of comments will be very, very helpful potentially for that. So yes, we're looking for ways to improve the textbook. This is just the first edition. Now, I didn't think it was going to be possible to be more pessimistic, John, in this matter. We basically said, yeah, there's probably a few thick rights out there. And you're saying there's no thick rights if you look closely. So you managed to be more pessimistic, but joking aside, I think you're making a really interesting point, and perhaps it's possible to distinguish between a sort of an input and an output way of looking at it. When we distinguished between thin and thick rights, we looked at it more from the output perspective, meaning we looked at, what's there at the end of the day, and we sort of use 5 criteria. We say a thick right is, complex. It's made up of a set of Hofeldian legal positions. It protects individuals' fundamental interests. It has a high threshold for justifying limitations, so it cannot easily be traded off against human interests. It is directly enforceable by the individual or their representatives, a point that Joyce mentioned in her remarks. And then lastly, it's got a dynamic character. It evolves over time. And it seems to me that you adopted a more input-based perspective, right? You said that really a thick right, to be a proper thick right, it has to have the right sort of motivation behind it. It has to be based on that ethic of non-instrumentalization, which I find a really fascinating idea. I do wonder whether we're both potentially operating on more of a spectrum than perhaps you were suggesting in your comments, but maybe I wasn't, sort of interpreting you correctly. And I think Sean and I wouldn't necessarily, want to resist the idea that there can be thin rights that can be quite powerful and that can, go some way in a direction of protecting fundamental interests, say, and that may be less easily infringible than other thin rights. But the more of that you have, basically, the more you are moving in the direction of a thick right, right? And equally, you might say with your, ethic of non-instrumentalization, it's possible that that's more of a spectrum too, isn't it? So, I think you mentioned the, sort of habitats, sort of rules, say the EU Habitats Directive that protects individual animals, or it can have that effect if they are sufficiently endangered. It can have almost a thick meaning behind it. But I'm not sure, would you classify that as non-instrumental? It would seem that the individual here is used as an instrument to serve the broader point of protecting species. There may be other rights where you have more of a non-instrumental approach to it, but even there, I would think, even in the context of human rights, we allow for some trade-offs when there's public interest that requires limiting the right. Would you call that a pure? Would you qualify human rights as being based on the ethic of non-instrumentalization, considering that they sometimes allow for some of those trade-offs? So I guess what I'm sort of gesturing at is, it seems to be more of a spectrum, in which case it can potentially align with how we think about thin and thick rights. But it's certainly very thought-provoking, and I'd like to discuss it more with you. And I think I'm going to just hand over to Sean in the interest of time. Perhaps he has something to say about John and Joyce's comments.
I'd just like to pick up one point, which actually was the last point that both of them made about, is the book too early? Is it, are there animal rights laws? And there's a lot of work going on, a lot of, interesting research. People are exploring all sorts of ideas, animal labor, animal trade unions, all of these things. I don't think there's a magic bullet. I think that, as Joyce said, it's about presenting to judges, getting them to understand language, getting people familiar, government, politicians, and individuals, society, getting them familiar with the idea. One of the things that Raffael and I want to do in the center, is to normalize animal rights law. Want it to be a normal subject. Doesn't mean people agree with it, but they can at least deal with it as a subject which is worth thinking about and worth debating. Maybe we should have put animal rights law ? But I think that wouldn't have gone down so well. So I think that, as I say, the last point for both of you. I think a lot of people, and fortunately Raffael and I are, a part of a big group of which both of you are also part, are just doing things, writing things, talking about things which are going to move, are going to move the needle. And yes, there's going to be a lot of small steps, but actually it's amazing how quickly public attitudes can change. So yeah, this hopefully this book will just be another small part, contribute to another small step.
Thank you, Sean, and also Raffael for those comments. I especially like, Raffael, your points about this potentially being more of a spectrum. It can be easy to cast a lot of these questions or issues in binary, mutually exclusive terms. Is this welfare or is it rights? And in many cases, it might be more of a spectrum. There might be more than two options, and that can enrich the conversation to frame it that way. And Sean, I also appreciate your reply, because yes, it might be early in the sense that a lot of the work is still to be done, but the publication of this kind of book is part of what can spur us to get that work done. So really appreciate you publishing the book, even if it is a little bit earlier than many of the laws the book discusses. Now, we have some questions and comments from the audience, and so I will read some of them to you, and we have plenty of time to discuss some of them. I will start with Ashley Nunes because anytime somebody mentions one of the hosts of the talk in a positive light in a question or comment, you'll automatically get bumped to the top of the list. So Ashley notes, I'm finishing my master's at Vermont Law. I chose Jeff Sebo's Saving Animals, Saving Ourselves, which you can see right here as my externship required reading. I'm happy to add Sean and Raffael's new text to my reading list. I'm interested in hearing more about Chapter 5. Assuming a philosophical and legal justification for animal rights, can you preview a human rights, non-human rights conflict and possible resolution? Thank you.
I'm happy to take that one. I think it's a really good question, and it's something that we'll have to think about more. The whole field, that is, what would those conflicts look like and how can they be resolved? So standard conflict might go as follows. You have, say, animals used in experimentation, right? So under an animal rights framework, depending on how exactly it will be structured, you would think that, potentially depending on the animal that's used, but let's say take an easy case, maybe a non-human primate. They're gonna have an interest in bodily integrity. They're gonna have an interest in being alive because they have interest in continued existence. If you adopted that higher standard, some people think sentience is sufficient too, but let's just operate under the assumption that these animals have a right to life and the right to bodily integrity. That's your, if you're thinking of it as a scale, that's one side of the scale. You have those interests and those rights of the non-human primates that are being used for experimentation. On the other side of the scale, you might have the human scientists' right to conduct scientific research, which is in some parts of the world, at least, a constitutionally guaranteed right. Now, what does that mean? Does that mean that the human scientists cannot carry out these experiments at all? We, I think, broach it briefly in the book. This will be the type of scenario we think where the interests of the animal weigh higher or more than the human's interest in carrying out the research, not least because there's other ways, today at least, of carrying out research that might get you to similar results. You don't have to use non-human primates to do that, right? So in this particular case, you would have a sort of a conflict where you see a sort of potential balancing that will be carried out by judges, and we hope they would, find that the animal's interest here outweigh the human's interest. But you may find cases where, the balance goes the other way around, where perhaps the infringement of the interest is not as problematic, is quite trivial, and there's a lot of gain to be had. The important point to realize here is that in most countries on this earth, with the exception of the US, human rights are already seen as something that can be balanced, that can be traded off to some degree. So rights aren't seen as categorical, as absolute. They allow for some limitations, and that doesn't take away from their being, human rights and thick rights. So that goes to my comment before about John. So some limitations are fine, but we have to allow for a high sort of threshold of justification. Trivial human interest will not suffice to override strong animal interest. So that's just a broad sketch of what a conflict and a balancing exercise could look like.
Okay, great. So for now, I'm going to go from question to question and try to have one person respond per question so that we can get to as many as possible. But if we get to the end and have space, we can let some of the discussions breathe more. So another substantive question comes from Katarina Schumacher. Since this book has an international approach, what happens when welfare is increased or rights are granted in one particular jurisdiction? Is there a ripple effect for neighboring jurisdictions, or does it backfire by sending harmful behaviors, wrongful behaviors like factory farming to other jurisdictions? For example, what were the reactions to these subtle changes like dissenting votes or pro-animal terminology?
Shall I do this one, Raffael? So I think that there's a certain amount of anecdotal evidence of, for example, research being moved to countries where The regulations, perhaps in relation to animals, are less strict. I would imagine that there is something similar in the commercial sector, where businesses are developed in countries where perhaps welfare regulations are less tight and so on. And I think that's probably inevitable in the nature of global trading and global living. Whether that's a reason for countries not to do it, though, I think is the pertinent question. In other words, should one country or a group of countries avoid, say, improving welfare laws and perhaps having which would perhaps make factory farms uneconomic or less economic? Should they still change their welfare laws, improve them, if you like, even though it has that economic consequence? And of course, many people would say that what's important is the improvement of the quality of life of animals, and therefore it should be done. I think perhaps taking the question even wider, any of these changes are going to have economic significance. Welfare law changes will put up costs. You may remember a few years ago, regulations improving the cage size, I think, of chickens, and the chicken lobby and the chicken producers put out advertisements saying, this is going to impact on children from poor families, because the increased welfare costs increases the cost of chickens, increase the cost of eggs, therefore increase the price of eggs, and eggs are a good source of protein for children and adults. So yes, I'm afraid these things do have consequences, and that's why, whether it's welfare laws or animal rights, that's why these things have to be viewed, considered, reflected on, and if they want to, accepted by society, realizing that there is an impact in these things. But we've been here before. We were here 60 years ago with environmental laws, with laws saying, yeah, you can't do some of these things. You can't let this stuff come out of your chimney or go into your rivers. Yes, I'm afraid there's a cost, but it's unacceptable to society. So there is a cost. It may have a cost of businesses moving. That is the nature of whether it's welfare or rights. And that's why it's so important, it seems to me, that society and the public have to be comfortable with what's happening and feel that the costs they're having to bear are justified.
Great, thank you so much. So I'm now going to pair a couple of questions together, because they both in different ways get at the idea that animals have intrinsic value and should not be instrumentalized. So the first one comes from Oda Malman, who says, yes, in Norway, the law of animal welfare says animals have intrinsic value regardless of the instrumental value they may have for humans. Do you think industrialized farming is legally compatible with the concepts like intrinsic value? And I might add, do you also think non-industrial farming, animal farming, is compatible with intrinsic value? And how useful and relevant is a concept like intrinsic value derived from philosophy when working with the law? Now, I want to put that question together with one below from Angela Fernandez, which is about the idea of instrumentalization. So Angela says, really enjoy hearing about this book and look forward to reading it. I think the challenge with using instrumentality, or whether there is an instrumental motivation as a litmus test, is that the motivation will always be mixed. The history of animal protection is full of examples where advocates use instrumental arguments in a strategic way, but are motivated by genuine concern for animals or the human and anthropocentric interests and the animal-focused inherent value interest, as they are often coexisting, and it would be a distortion to reduce one to the other. So I don't think we would want to hinge right or not right on something like the use or not use motivation, right? And so to sort of summarize what I take to be the main point, we can often and do often use each other in ways that are compatible with full respect and compassion for each other, right? Like when I buy something, I use the cashier to complete the transaction, but I'm still respecting that person as a rights holder, right? So when we put these questions together, the sort of general question is, when we recognize that animals have intrinsic value, what forms of use is that, and is that not compatible with? And for example, would industrial or non-industrial animal farming make the cut? And how is use or non-use a good test, given that use can happen in a respectful and rights-respecting way?
Yes, I think those are excellent questions. I'm going to take a first stab, and I'm sure Sean may have something to add as well. I think it's a great question. Intrinsic value. There's quite a few jurisdictions where the intrinsic value of animals is explicitly recognized, but even those that don't recognize it or sort of state it explicitly are still based on the idea that as sentient creatures, animals have intrinsic value. The really problematic bit, of course, comes, as the question suggests, when returning to the types of uses that we're still subjecting these animals to. Are they compatible with the fact that these are sentient creatures that supposedly have intrinsic value? The book doesn't answer that specific question explicitly, but I personally have my doubts as to whether that's a compatible take you can have on this matter. I think Jeff makes a really interesting point. We can potentially think of it in terms of the sort of Kantian distinction between using someone as a means and using someone as a mere means, right? So the latter being the purely instrumentalization sort of version, and the first one being a version that's compatible in his framework, and we might say more broadly in other frameworks. Yes, I think using animals, and we explore accounts such as Donaldson Kimlicka's that conceive of animals as being part of shared human-animal societies, where we can use animals to some extent, where, say, you can use the wool of a sheep, for instance. These kinds of worlds are possible according to some animal rights theorists, not according to abolitionist theorists, and we discussed that division, but they're possible according to some. So use is possible. Using animals as a means is possible, in the same way as using humans as a means is possible. If I go, to the corner shop and buy something, I use the cashier as a means to get that, loaf of bread. What I think animal rights is opposed to, certainly, and that comes, takes us back to John's input, is using animals as mere means, right? As beings that don't have any intrinsic value. And perhaps just to sort of add something briefly to Angela's specific comment there, I think that's a really interesting one, and it's something that comes out in the history part of the book, where we talk about the different welfare laws, where they're coming from, and the different motivations that went into it. And I think it's very much true that to this day you will find legislation, welfare legislation for the most part, that is based on both recognizing animals as having intrinsic value, and on some instrumental criterion such as making the meat taste better. That's still there in EU directives. If you look at it, this is still a sort of law that's in force now. And yes, I think it allows me to say something very briefly about John's comment. I think the non-instrumentalization concern is an important one in animal rights law. And it can, to some extent, be captured by this idea of a high threshold of justification, right? So this threshold essentially allows you to ensure that use is possible, using animals as a means is possible, but not using them as a mere means, because that's not justified under that sort of thick rights framework. Okay, I'll leave it there.
Can I just pick
Okay.
up one part of the question, Jeff? And unfortunately, sort of separating them that you put together. Raffael knows this. I have great difficulty with these phrases like intrinsic value, sentient, dignity. I shouldn't do. These should be great words. These should be great phrases. I was just looking at the EU, one of the EU treaties, member states, animals are sentient being, and you read that and you go, wow, that's great. That's terrific. We're really motoring now. We're really cruising because they recognize they're sentient. And then it all goes quiet. And in the EU one, it then says, yes, we have to have full regard to their welfare, but we do have to respect religious rights, cultural traditions, and regional heritage. So, yeah, we have to respect recognize their sentient, unless we're doing something we've done for generations, in which case it's all right. So I have great difficulty with those sort of words. And when we teach the subject, I sort of put these words up and go, so it's all solved now, is it? Are we okay? And then the students see how it's simply not followed through. So I have great difficulty with them. I would like them to have the meaning, the normal, ordinary meaning. I would like, intrinsic value or dignity to be interpreted in a meaningful way. The simple fact is that welfare laws, in many cases, simply don't. And I think that one of the issues that that sort of is relevant for animal rights law is the fact that a lot of welfare has over the last sort of 30, 40 years altered or been unwilling to accept what should be a straightforward meaning of welfare laws and enable them to fit into industrial practices that really don't fit with those words. And over and again, you see laws talking about physiological needs and all these things. And you look at a particularly factory farming, you say, this is just not compatible with these laws. So to go back to the first question, first part of the question, I have concern that these words do not have the meaning that they really ought to have in plain and simple terms. So I don't really, unfortunately, don't see them as a route to a solution.
Yeah, thank you. That is really, really helpful. I mean, I think I take the spirit of the point to be the words or the concepts can potentially be useful, point to something significant, like sentience is potentially morally and legally significant, but merely paying lip service to the term in a declaration or in constitutional language, and then not making any of the social or legal or political or economic changes that would be needed to actually respect and have compassion for sentient beings. That is where the problem lies. I expect is the analysis, in which case I fully agree. Now, John, you also raised your hand. I would like to pass it along briefly to you if you have anything you would like to say. And then I will insist that we get back to the questions so that we can ask at least one or two more. So John, did you have anything you wanted to add?
Yeah, no, yes, very, very briefly. Perhaps it's already been covered by what you said, Jeff. So I hope I'm not just repeating myself. Yeah, I think we have to allow conceptual space for lies, deception, and incoherence in the law. And so when I speak of an ethic of non-instrumentalization, which I should update, given Raffael's remarks of not mere instrumentalization in the Kantian sense, and then people can use the big words that Sean points out, inherent value, dignity, just like the Swiss Constitution does. But we have to allow space for mistakes, lies, deceptions, and incoherence, and we can say, look, from an objective point of view, these are lies, deceptions, incoherent statements that the law and lawmakers make, and if they were really genuine, this is what an ethic of not mere instrumentalization would entail. Factory farming wouldn't be compatible with this, and several uses of animals would not be compatible with this ethic. Of course, one has to then say what this ethic entails, but we'll leave that to another occasion.
Can I just come in
Great.
briefly on this, Jeff? I don't want to interrupt.
Fine, whatever. Do whatever you want.
We'll take over from now on.
Go
You can
for
log
it,
out,
go for it.
Jeff. Sorry. No, it's just, I think it's a really, pertinent observation that, you and John were making there. I think there's sort of, glass is sort of glass half full, glass half empty type situation. You've got those terms in the, legislation, or in a lot of legislation. The glass half empty way of looking at it is, oh, this is just a fig leaf, it's deception, they're sort of co-opting these terms, but then they're not doing anything with it. But there's also a glass half full, perspective, where these are now terms that are officially, recognized in legislation that future animal rights lawyers can come and use to their advantage, right? And what we emphasize throughout the book is that animal rights law is a lot about people like Stephen Wise and others all around the world using existing tools that the law is already giving them in really creative ways, and trying to leverage what's there, using it as a hook. So I think that that's a really interesting observation that you two guys were making there.
Yeah, I completely agree. I think there are many interventions that are not by themselves enough to liberate animals or improve the welfare of animals, but they can be useful when combined with other interventions, right? So merely passing a law will not help any animals, but that together with various social changes might. Merely changing hearts and minds might not itself be enough to help animals, but doing that together with changing the law and making other changes might. So I agree, this is a systems approach, and we need lots of different things happening jointly in order to bring about progress. Okay, one more substantive question, and then there might be a quick lightning round. So the final substantive question comes from Jeffrey Sine, who says, given that this book focuses on animal rights, I wonder if the authors engage with the critique of rights that constitutional law scholars like Mark Tushnet in the US have explored. Tushnet, as an example, argues that rights are indeterminate, incoherent, can obscure the actual operation of the law in society, and can stifle social solidarity, among other problems. So is there a difference of the rights framework or a defense of the rights framework in light of these sorts of critiques?
Sean, should I take that one? So yes and no is the answer. So yes, we do engage with some critiques, especially in the philosophy chapter, where we talk about sort of ecofeminist critiques of the liberal rights framework more generally, where we sort of look into conservationist critiques of the individualistic approach, and we look into contractualist critiques, although those are not necessarily sort of aimed at rights specifically as a potentially problematic idea. So that's the yes part of my answer. The no part is we have to sort of make certain assumptions for the purposes of this book. And it's quite a short book, as you'll see. So we basically have to assume that the readers will buy into broadly the logic of, rights being at least something to be explored. So we don't have a chapter, say, that just, goes through all the fundamental questions and debates as to whether there should be rights in the first place at all. So we just assume that the reader is open to those ideas. But, I grant the point, there's much more to be said about the concept of rights as such that we could not tackle in this book.
Okay, excellent. Lightning round. Okay, so I want one sentence answers to these questions. So given that this is about international animal law, will the book be published in languages other than English?
Gosh, I wish our publisher was here. Unfortunately, she's down with COVID. Short answer, I do not know. I would like to think so.
Excellent. I will take that as a hopefully. Another question, one sentence answer. Would this be a good book to teach in an undergraduate animal law and policy class?
Absolutely.
That was a very concise answer. Okay, thank you. Another comment, which you can briefly respond to, is that Rowan Wilson, one of the judges who was congenial to non-human rights at the New York Court of Appeals, has now been confirmed as New York's first Black chief judge. So is this good for non-human animals? Is it good for animal rights?
Yes, he wrote a fascinating piece for that. So congratulations to him.
Today's dissent is tomorrow's majority.
Excellent, excellent. Yeah, I completely agree with that. Okay, final part of the lightning round. I now want one word answers, yes, no, or maybe. So I assume that all vertebrates like mammals and birds and reptiles and amphibians and fishes should have legal rights. What about invertebrates like octopuses? Yes, no, or maybe?
Yes.
Yes.
What about invertebrates like ants? Yes, no, or maybe?
No.
Depends.
Ooh, I disagree. Stay tuned for reasons why. What about blades of grass?
Yes.
No.
No.
What about Chat GPT?
Hmm.
Not yet.
Ah, interesting, interesting. Well, that is a provocative place to end the conversation. So let me just say thank you very, very much to Raffael and Sean for writing this book. It really is a groundbreaking book. It brings together all kinds of important theoretical and practical work about animal law, again, from an international perspective. And I think it can really be used as a field building tool. It can help people do research. It can help people do teaching. It can help us build momentum behind the idea of animal law and normalize the topic and the field of animal law. And I think that really will constitute an important step on the path towards actually achieving rights for animals. And so thank you very much for writing this book and for sharing it with us. And thank you again to John and Joyce for offering your commentary. We really appreciate it. Just a quick thank you additionally to the Brooks Institute for Animal Rights Law and Policy for sponsoring this series, including this talk, also for the NYU Mind Ethics and Policy Program for co-sponsoring this particular panel, and to Becca Franks and Sophia and Phoebe for helping to make this event happen. Thank you all. And finally, of course, to everybody in the audience for attending and participating as well.